liberals and feminists have a long list of rights that they demand at the taxpayer's expense, but none is demanded as firmly as the so-called reproductive rights. Apparently, life, liberty and pursuit of happiness is outdated and should include right to reproduce and then murder offspring in utero, if the Constitution is to reflect the current climate among those who need government assistance. While it's bad enough that Americans are allowing children to be killed while in the mother's womb, thanks to some Obama-era policies and judges who like to legislate from the bench, we will now be forcing employers to provide oral contraceptives and even providing abortions for illegal aliens. According to the Conservative Review, these are cases where the president decided that neither employers nor the United States government are to be held financially responsible for the results of the sexual activity of those legal or illegal residents of the U.S. You see, unlike appendicitis, pregnancy is 100% preventable, and making other people pay for your choices is not only socialist, it's just plain crazy. Since a court has now ruled that illegal aliens have the right to come here and demand access to an abortion, what a Pennsylvania judge did last week may not be surprising, but it's no less insane. Judge Wendy Beetlestone, an Obama appointee to the U.S. District for the Eastern District of Pennsylvania, ruled that the Trump administration must continue enforcing the Obama-era contraception mandate, forcing employers to directly or indirectly provide contraception as part of their mandated insurance benefits for their employees. As part of a growing trend, Beetlestone applied the injunction nationwide against yet another good policy from the Trump administration, this time at the behest of Pennsylvania's Attorney General. Obama's legacy lives on through the courts. This is troubling on many levels, not the least of which being that it's just another way for those who disagree with President Trump's policies to circumvent the decisions of the president that the people elected. Judges are in non-elected positions to shield them from the backlash of people who might disagree with their decisions. Unfortunately, that means that if an unconstitutional one slips through, or is shoved through by a less than ethical party, their decisions are extremely damaging. So, how can a state government obtain standing, to sue for the imposition of a contraception mandate? Here is the kicker from Judge Beetlestone. The Commonwealth's concern is absent available cost-effective contraception. Women will either forego contraception entirely or choose cheaper but less effective methods, individual choices which will result in an increase in unintended pregnancies. That, in turn, will inflict economic harm on the Commonwealth because unintended pregnancies are more likely to impose additional costs on Pennsylvania's state-funded health programs. In October, President Trump stopped enforcing an Obama-era arrangement to coerce employers into covering contraception and abortifacients in violation of their religious beliefs. But as I observed in the Masterpiece Cake Shop case, this is about more than religious liberty. It's an issue of property rights. No employer should be forced to cover a particular drug, especially one that is so readily available. Acknowledging that there is no evidence of harm of people dying on the streets with pregnancies they can't handle due to the $20 burden of birth control. The judge cloddishly defended her injunction by asserting that there is no need to wait for the axe to fall before an injunction is appropriate, after almost every lower court upheld Obama's new scheme. The Supreme Court refused to rule on it, allowing the muddled status to continue in the lower courts. In 2015, in the Stormans case, the Ninth Circuit ruled that a Washington state pharmacy must provide essentially every type of contraception under the sun, even though 30 other vendors sold all the products within 5 miles. SCOTUS refused to grant an appeal to the owners of the pharmacy. Now, a single Pennsylvania judge is able to force the entire scheme on a subsequent president. The legal system and corrupt courts have elevated the right to an abortion or contraception to such a level that now America is becoming a magnet for abortion chain migration. Remember when the U.S. Court of Appeals for D.C. created a right for illegals to come here and demand an abortion? The ACLU has 2 more customers to sue the government for such a right. And guess what? They are going back to Judge Tanya Chutkan, the same D.C. federal judge who issued the first order. This year will no doubt be remembered for many things: President Trump's political shakeup, scandals plaguing not only Hollywood but also Washington. Not to mention North Korea and the dangers that it brings with it. But all of those changes will pale in comparison to the potential damage that can be done by liberal activist judges who find it within their purview to rewrite the law to reflect their own personal opinions.